And here's the other thing, and look, I will mention a case. It's a federal case, and I'll try to shorten it up. And to some extent, you gotta believe me, because I can't present all of the evidence in a short time to absolutely convince you that this guy is innocent. But this is a well-known case in Macomb County. There are some really crummy people in this world. One of them is a guy by the name of Hudson, another one by the name of Contesti. These are conspirators who decided that they were going to line their own pockets by bribing school board officials in order to get contracts to them to make a lot of money off of these school systems in Macomb County. The case broke. Hudson's been convicted. Contesti's been convicted. There was a sheriff's deputy by the name of Ron Lupo, right? And he was a partner with this guy, Ray Contesti, in some business deals after he retired from the sheriff's department. I'll make it short. In like 1990 something, this guy, Hudson, bribed a fellow named Gardner in the East Detroit school system to start getting the East Detroit construction business. A couple of years later, this guy Hudson bribed a guy named Contesti in the Clintondale school system to get their business. Unbeknownst to this guy Lupo, who was a partner with Contesti in a consulting firm, he made a deal saying that I've got a chance to put together a consortium who's going to put together an equestrian center in northern Macomb County. It's going to be big money. These guys came to him and said, we're interested in that. And they basically made a deal with Lupo saying that, look, in exchange for us being one-third partners on that future deal, we're going to share with you the income stream from projects that we have already underway. The evidence was clear that by 1994, all of the bribing was done with these people. Hudson didn't meet Lupo until the end of 1994, after everything else happened. Because the law of conspiracy in the United States is wisely that the last conspirator in is just as guilty as the first conspirator, as long as they had knowledge of the overall objects of the conspiracy. This case went to trial. A good friend of mine was the trial attorney, and this is one of those things where even excellent trial attorneys have these flaws in trial strategy, which wise United States attorneys and the Attorney General of the United States said, okay, the Jenks Act says what it says, but you can't be serious. I mean, that's no way to run a courtroom, all right? So we ignored it. We gave the discovery material immediately after indictment. However, under other administrations, appeals were taken, and the United States Supreme Court said, yeah, it's inconsistent with Brady, but not completely, because you're still giving the material over. You're just not giving it over as fast as some people might want it. And so Congress was upheld, the statute was upheld as constitutional, and so now in federal court, instead of it being the age-old, easy flow of material back and forth, federal prosecutors will hold back things until the last second. Not all federal prosecutors. Some are still kind of stuck in the old good ways that they will just make it available as soon as possible. But what happens is that you get new assistant U.S. attorneys into the mix, and depending who is training them, they read the law that says you don't have to produce this stuff. You create a culture in which you hold back things more and more and more because you feel that somehow that's part of your job. You're the government lawyer. You're supposed to protect the government secrets. That's the other thing that's wrong with the country. Everything is national security and secrets. It's not the same free country it used to be. But people hold it back because there's this culture that it's morally and legally okay. And then what happens in some cases, you get people crossing the line and they don't even know it. And so Brady versus Maryland in state courts is still in full force in effect. In fact, in Michigan, there's not only Brady, but there's a state case of the Bay County Prosecutor versus Bay County something. That takes everything that was said in Brady and makes it applicable to all Michigan courts. So the flow of discovery material in Michigan courts is still good, but in the federal courts it's been hampered as a result of Congress and the Supreme Court approving the literal interpretation of the Jenks Act. That's probably a little too technical, but it bugs me. I'm sorry. Let's go to, I'm sorry, Professor, I'm going to call on somebody else.
There's a hand up.
Oh, yes, okay, yes.
Isn't it up to a judge to determine whether someone can be withheld from the defense?
Yeah, the question is, isn't it up to a judge to determine whether somebody can be held from knowledge of the defense? And the answer is yes. What I was shorthanding is that before a judge can make that determination, however, the judge has to have it brought to his or her attention that this is even an issue. The way to do it is to present your discovery material to the defense counsel and say, I am holding back the affidavit of confidential informant numbers 7829 and confidential informant 7876. And these are the reasons. And then the judge makes a determination whether those are valid reasons. But if the government lawyer never says I'm holding back this information, how does the judge never even have to make a ruling on that? And that's, I mean, that is pure hardball prosecutorial misconduct. And does it happen often? No. I mean, look, what these things that I'm rattling about, I'm not suggesting that this is endemic or common, but if it happens once, it stinks. It's bad. And one of the things I wanted to talk about that Professor Zalman raised is that one of the real difficulties in attacking this problem is that most prosecutors have the correct sense of obligation, and most prosecutors get it right. A real weakness in the system is that there are a lot of mistakes made by defense attorneys in the course of trial. There's no easy cure for that, other than that you have to be aware that that's a problem. And a part of why that happens is that under the current Michigan Supreme Court, there is such a mandatory rush to bring cases to trial. It's part of the overcrowding of the system. And people are being forced to trial where their attorneys are saying, I need more time. And the courts used to say, hey, look, whatever you want, Madam Defense Attorney or Mr. Defense Attorney, you're going to have, because we want you to be fully prepared. Nowadays, the trial date, if you've got another trial date, another circuit, you're told to juggle, and you start your case just as soon as you can get done with that one. Sometimes subpoenas don't get out. There's a big problem just in terms of the mechanics that is part of this press of fast justice. It's you know, fast justice is to justice as fast food is to food. You know, it shouldn't be. Yeah. Yes.
I'm Cindy Barish, Jeffrey Muldown's sister.
Did everybody hear that? This is Jeffrey Muldown's sister.
And I just wanted to point out to you that the jurors in both my brother's case and Michael's, the second trial, all believe that they were both innocent. As a matter of fact, my brother's trial took place a year before Michael's, and 3 of the jurors from Jeffrey's trial sat through Michael's because they couldn't believe he was being tried again. But I wanted to thank him publicly for everything that he did, and I know that it took a lot of guts for him to do that, and our family was praying for you the whole time you went through all of that, and I don't think that was fair. But I do have one question.
Sure.
Are you ever going to run for prosecutor again? You should.
Yeah, no, thank you. It's a nice question. It's complimentary, but I decided not to, and the reason is that when I first became prosecutor, I said, I want to do this for 3 terms. 3 terms was artificial, but the reason I did it is that I was a political science minor, and I just kind of admire the framers of the Constitution when they talk about how public service should be. That you should get into public service, get away from your farm or your printing press for 1 or 2 terms in Congress or whatever, leave it and go back, instead of making a career out of it.